Ladies and gentlemen, I am your lecturer, taking you on debt recovery lectures. I will be taking you on methods of recovery of debts. This will be part 2 of the lectures. I have taken you on part 1. In part 1, I considered various methods for the recovery of debts. I took you and taught you on one of the methods, which is the threatened and actual publication of names of debtors in newspapers, the use of debt collectors, employment of thugs, liability of debt collectors, acting as agents of their principal, detention of debtors, realization of security, and the various problems associated with the realization of security, failure to obtain the state governor's consent to create a mortgage on landed property, the requirement of governor's consent in respect of equitable mortgage. I took you on what I call the end justifies the means approach to debt recovery. Use of the police, security agencies, and Economic and Financial Crimes Commission in Nigeria in the recovery of debts. I taught you how debts can be criminalized. There is the woman approach in the recovery of debts. The advantages in sending ladies to speak to debtors. I also taught about the psychological method, which is one of them is the woman psychological method. Then there is the diabolical method. It might have its advantages. I'm not an expert in that area. Then a debt can be, when being created, there can be a guarantor, so that if the debt is not being paid, the guarantor can be made to settle the debts. So, all these that I discussed in part 1 of the lectures has its advantages and disadvantages. Today, we will be discussing on the use of legal practitioners in the recovery of debts. Many do not want to involve legal practitioners in the recovery of debts. Why? Because they believe the legal practitioner will proceed in his debt recovery actions. He will proceed to court. And in Nigeria, most people do not want their matters to end up in court because of delay. There is a land case I've been doing now. I've been involved in from High Court to the Supreme Court. Since 1995. How many creditors will want to keep their matter in court for 10 years? Even the debtor, such does not favor him, because if he loses in the long run, the interest that has accrued over the years will be much more than the principal debt. After trying all the various methods that I've talked about in part 1, the likelihood is that the creditor will end up employing a legal practitioner in the debt recovery process. What will a legal practitioner do? The first thing that a legal practitioner will do in the debt recovery exercise is to write a letter of demand. A letter of demand, a good letter of demand is not as simple as we think it is. When I started practice with a law firm. We were doing a lot of debt recovery matters for banks and companies. The first thing my principal asked me to do was to write a letter of demand of a debt. I wrote my letter, had it typed, and forwarded it to my principal. He looked at the letter and invited me to his office. And he told me that my letter is at best a love letter. He brought out some old files and he asked me to study how to write letters of demand. Today, I have written books on debt recovery. One of them is this, the book Debt Recovery, Laws and Procedure with Forms and Precedents. This is the 4th edition of this book. In these books, we have forms and precedents that you need in the debt recovery exercise. You will find letters of demand. Your letter of demand must be well couched. You must state the principal debt. You must state the accrued interest rate, and that the interest rate will continue to accrue as so percentage until the debt is fully settled. If you do not state such details, the debtor will oppose and object to the issue of interest rate. And should you proceed to get judgment, you will probably be given awarded interest rate according to the rules of civil procedure. But if there is an agreed interest rate, in Lagos State, for example, you'll probably be awarded 6%. While the credit, when it was being made available to the debtor, he had signed that he will be paying 14, 20-something% as interest rate. So, after you have written a letter of demand, the debtor might or might not receive the letter of demand. It's possible he has relocated and is no longer living where the creditor believes he's living. So, a lawyer involved in debt collection should visit the debtor. If you do not visit the debtor personally, you can get one of your clerks to visit the debtor's premises. The purpose of such visitation is to assess. You want to know whether he will be capable to settle the debt. You want to know whether he's still located in the address that the creditor gave to you. I remember many years ago, I was briefed to recover a debt. I practiced in Lagos. I was briefed to recover a debt where the debtor said to be living in Sango Ota, which is about 2 hours drive from Lagos. I wrote a letter of demand, sent it by post, but I followed it up with a private visit. When I got to the address, the man was nowhere to be found. Neighbors now told me that he has relocated to the UK. So, no problem. I briefed a private investigator who investigated and got his address in the UK. So my plan then was to institute an action, and which I did. I got judgment in the Otta High Court. I served him by substituted service. And the plan was to register the judgment in the English court. But I could not make progress because the bank, my client, had trouble and the bank folded up. So visiting the debtor is very important. It might be when you visit the debtor, you start the process of negotiation. Or the debtor might visit you and you start the process of negotiation. Negotiation is very important in debt recovery matters. Most banks write off debts and farm these debts out to debt recovery agents and legal practitioners. When you are negotiating with the debtor, you must have it in mind that you have to make some concession, and you must get your clients to make some concession. The principal debt might not be negotiable, but you should be able to negotiate the accrued interest rate and help the debtor to settle the debt and waive part of the interest rate. Under the new Lagos State Civil Procedure Rules, there must be evidence that parties have tried to settle the matter out of court. And how do you do this? You write a letter of demand. You show evidence that you invited the man for a meeting and that he came, he wrote a letter of reply. And I mean, these are all the things that you will have to show before the matter can proceed to trial. So even the law courts now and the civil procedure rules recognize the need to have negotiations before you file an action. A legal practitioner must know that a debt recovery exercise must never get to trial. Yes. Because if a debt recovery matter gets to trial, you'll be stuck at the trial stage for years because of congestion in our law courts in Nigeria. So, a legal practitioner must examine the documentation. He must consider various procedures for settlement, for getting speedy resolution of a matter. Summary judgment procedures, garnishee procedures, Mareva injunction. I will discuss these full in details in part 3 of these lectures. It is my view that special courts ought to be set up for the trial of debt recovery matters. In Lagos State, we have procedure under the civil procedure rules for management of cases on fast track. But under the rules, there's a limitation of the type of debt that qualifies for fast track. But if special courts are set up for the recovery of debts, there will be no limitation as to the amount of money that can be recovered in such courts. Fast track is good, but it has its advantages and disadvantages. It can lead to appeals. I have never liked the idea of imposition of fines on claimants or even defendants who are not able to meet the stipulated dates for procedures to be followed under the rules. When we look at the fast track rules, there's provision sometimes for the day-to-day hearing of a matter in court. Let's look at the reality of going to court in Lagos metropolis. A lawyer might spend about 2-3 hours getting to court every day. The witnesses and the clients too. When you have a fast track and a day-to-day hearing of a matter, a lawyer spends about 3 hours getting to court, another 2-3 hours returning to his chamber or his home. If you ask him to come to court the next day, how feasible is that? The judge himself spends maybe 2-3 hours too to get to court. So when we look at, yes, there is need to have a matter tried expeditiously. How will a busy lawyer keep to the time limit provided for under the rules? If a counsel cannot ask for extension of time to comply with the provision of the rules and is made to pay fine, will this not be a breach of the client's right to fair hearing? Fair hearing and justice should not be sacrificed on the altar of speed. Onojan JSC said in the case of Oko Memorial Farms Limited and another versus NA and CB Limited, a 2008 case. What did he have to say? Let me quote that to you. He said to the effect that we should not sacrifice the cause of justice on the altar of speed. He said, even though it is the desire of all involved in the administration of justice to uphold the principle which states that justice delayed is justice denied, it is equally unacceptable to encourage or do injustice in an attempt of speedy dispensation of justice. Justice may be slow sometimes, but it will surely arrive at its destination. A little patience and care by the learned trial judge in the instant case would have saved time and energy and money if the court had but adjourned the purported counterclaim and you had so much more to say. I believe, fast track or no fast track, special courts should be set up for the trial of debt recovery matters. A legal practitioner in the debt recovery exercise must master all the procedure for summary judgment. He must master the procedure for garnishee actions. He must master procedure for preemptive actions. This is Mareva injunction and Tompila orders provided for under the rules. In part 3 of these lectures, I will be taking you through these procedures. I appreciate all those who have commented on part 1. Your comments on part 2 will be appreciated so that we may improve the quality of this lecture. I thank you for listening to me. Good day.